but there was no evidence that he colluded with any other person, either to prepare the documents or to assist him at the lands office. The offense cannot therefore stand where the purportedly unlawful act was committed solely by the actions of the accused himself, and consequently the accused is found not guilty in count 5 and is acquitted under section 215 CPC. So in conclusion, the court has found that the accused is not guilty in all the 5 counts and is acquitted under section 215 CPC. The charge or lien upon the thing in question, or any right arising from or dependent upon holding possession of the thing in question. The prosecution case is that the accused person stole a title deed, LR number 10422/13, which is the property of George Oraro and Dr. David Silverstein, who are the executors of the estate of Livia Lepo Trench, and the said theft is said to have taken place at the lands office in Nairobi. From the definition above for the offense of stealing to be established, there are certain key elements that must be proved, and the first and key is the issue of ownership. In the case of Wycliffe Anyona Nyabuto versus Republic, the court stated that the essential element in a charge of theft is that the person accused fraudulently converts a property which is capable of being owned so as to deprive the owner of such property. In their submissions, the defense cited the case of William and 2 others versus the Republic, where the court stated as follows, that the second element of the offense is a proof of ownership of the items by the complainant. In my view, in the present case, the prosecutor did not prove beyond reasonable doubt that the items in the charge sheet belong to the complainant. End quote. Coming to the matter before this court, the question is, have the prosecution proved ownership of the stolen property? The particulars of the offense, as stated, are that the accused person stole a title deed, the property of George Oraro and Dr. David Silverstein, the administrators of the estate of the deceased Livia Trench. According to the defense, there was no such title in existence, and therefore the charge could not stand. Indeed, from the evidence on record, the prosecution case seems to be that the accused stole a mother title, number 10422, which was used to create title number 10422/13, which was a subdivision of the mother title. This was confirmed by PW1 James Kituku, advocate, who testified that the accused appeared in their office and asked for the mother title in order to lodge a transfer of parcel number 10422/21 to his name. He stated that he could not give it, that is the mother title, directly to the accused, and therefore he instructed their conveyancing clerk, who was tasked with the duty of presenting the same at the lands office and returning it back to the office. The conveyancing clerk testified as PW5 and confirmed this position. It is clear, therefore, that on the 5th of August 2016, when the accused was alleged to have stolen the title deed number 10422/13 in the names of George Oraro and Dr. David Silverstein, there was no such title deed in existence. In his testimony on cross-examination, George Oraro, senior counsel, testified that when he realized that parcel number 422/13 had been transferred to the accused, he did not file any complaint to the police because he was aware that the issue of ownership had not been determined. And he decided to wait for the determination of the dispute in the ELC case in Nanyuki Law Courts, where the issue was pending. The issue of ownership of the disputed plot, therefore, is therefore a civil matter which was the subject of a live civil suit which is pending before the court in Nanyuki for determination. And therefore, the charge cannot stand without proof of ownership. The defense admitted that the accused had established a legitimate claim over the said title, that is 10.422/13, which he is alleged to have stolen, and thus making the charges of stealing against him untenable. The defense relied on the case of Robert Onchwari Orina and another versus Republic, where the court held as follows, and I quote, that for an accused person to be convicted of the offense under section 268 of the Penal Code, it is incumbent upon the prosecution to prove that he or she dealt with the property of the complainant fraudulently without any claim of right, or converts it into his or her own use other than the general special owner thereof. That intention is executed in a manner to deprive the rightful owner of the property permanently. The defense also relied on the case of William and two others versus the Republic, where the court refused to uphold a conviction on a charge of stealing after it was established that the accused had a claim over the item alleged to have been stolen. The evidence on record in this case, and which is not disputed, is that the accused person had entered an agreement with the late Livia Lepoux Trench for sale of parcel number LR 20422/13 to the accused person, and the accused person had paid the full purchase price through the deceased's then advocates, who testified as PW2 in this case. The said counsel confirmed that he drafted the said sale agreement upon receipt of instructions from his client. He stated that he received the purchase price, which he sent to the firm of Oraro and Company advocates, who were acting for the administrators of the estate of Livia Trench after she passed away. PW2 and PW8 both confirmed that they had received the entire purchase price paid by the accused person, and what was remaining was a transfer of the land to the accused person. It is clear, therefore, from the foregoing, that the accused had a reasonable claim or interest in the property, and therefore another key ingredient of the offense has not been proved. Section 8 of the Penal Code also provides a full defense for a person asserting a bona fide claim of right. It provides, and I quote, that a person is not criminally responsible in respect of an offense relating to property if the act done or omitted to be done by him with respect to the property was done in the exercise of a honest claim of right without intention to defraud. It is a finding of the court, therefore, that the accused managed to demonstrate a reasonable claim over the title, and therefore the prosecution failed to prove its case beyond reasonable doubt in respect of the first count. The accused, therefore, is found not guilty and acquitted under section 215 CPC. In count 2, the accused is charged with the offense of making a false document contrary to section 347A of the Penal Code. The particulars are that on or before the 3rd of August 2009, at an unknown place within the Republic of Kenya, jointly with others not before court, with the intent to defraud, knowingly and fraudulently made a certain document, namely an agreement of sale for land parcel number LR number 10422/13, Nanyuki Township, dated 3rd of August 2009, purporting to be a genuine and validly drawn document by Mwangi Kariuki advocate, a fact he knew to be false. Evidence before this court sorry. The prosecution was required, therefore, to lead credible evidence to show beyond reasonable doubt that it was the accused person who made the agreement for sale of the said parcel of land. Section 70 of the Evidence Act is clear that if a document is alleged to be signed or to have been written wholly or in part by any person, the signature or the handwriting alleged to be in that person's handwriting must be proved to be in his handwriting. And in this case, the prosecution was to provide evidence that the accused made the agreement. There was no such evidence that was given before this court. During the hearing of the case, it came out clearly that the so-called false document, which is the agreement for sale of land, reference number 10422/13, and produced as exhibit number 6, was drafted by Mwangi Kariuki advocate. The said advocate appeared before this court as a prosecution witness. Number 2, he confirmed that he was the one who drafted the said agreement on instructions from the seller of the parcel of land. He confirmed that the agreement was genuine and valid. The circumstances that constitute the making of a false document are set out in section 347 of the Penal Code, which provides that any person makes a false document, any person makes a false document who A, makes a document purporting to be what in fact it is not, and PW2 having admitted to having drafted the agreement, it follows that the allegations against the accused in count 2 are not true, and this is the basis of the finding of the court that the accused had no case to answer. It was the finding under section 210 CPC. In count 3, the accused is charged with the offense of uttering a false document contrary to section 353 of the Penal Code. The said section provides that any person who knowingly and fraudulently utters a false document is guilty of an offense of the same kind and is liable to same punishment as if he had forged the thing in question. So the word utter is defined under section 4 of the Penal Code as follows, and I quote, utter means and includes using or dealing with and attempting to use or deal with and attempting to induce any person to use, to deal or act upon the thing in question. According to the section and the definition above, it is an offense if one knowingly and with the intent to defraud utters a false document, and that is uses or deals with or attempts to use or deal with or attempts to induce someone or some other person to use or deal with or act upon the document. thing uttered to him. The accused, in this case, cited the case of Mary S. Peter versus Republic, where the court held as follows in regard to an offense of uttering a false document. That for the offense of uttering a false document to be established, two elements must be proved. First, that the document is false, and second, that the accused person was aware of the same. In the case of Kefa Moses Mogoi versus the Republic, the Court of Appeal stated that the offense of uttering a false document under Section 353 of the Penal Code is proved if a person knowingly and fraudulently utters the document. The question here then is, were these elements established by the prosecution? As already stated above, the prosecution did not prove that the agreement was forged and that it was therefore false. The prosecution did not also prove that the accused knew that the agreement was false. The prosecution, having failed to prove that the document, that is the agreement, was false, and that the accused knew that it was false and that he intended to use it fraudulently, the offense of uttering a false document was therefore not proved as required by the law, and the same is dismissed and the accused is acquitted under Section 215 CPC of the offense. In count 4, the accused is charged with the offense of obtaining a false land registration, obtaining land registration by false pretense, contrary to Section 320 of the Penal Code. The section provides as follows, and I quote, that any person who willfully procures or attempts to procure for himself or any other person any registration, license, or certificate under any law by any false pretense is guilty of a misdemeanor and is liable to imprisonment for 1 year. On the other hand, Section 312 of the Penal Code defines false pretense as any representation made by word, writing, or conduct of a matter of fact, either past or present, which representation is false in fact, and which the person making it knows to be false or does not believe to be true, is a false pretense. The question then is, did the accused person obtain registration of parcel number 10422/13 by false pretenses? The ingredients of the offense of false pretense from the definitions above are that there must be a representation on matter of fact about the past or present. That representation must be false and it must have been made with the intent of defrauding someone of his property. It must have been acted upon to the disadvantage of the complainant. The prosecution must therefore prove these ingredients to succeed in a case of obtaining registration by false pretenses. In the case of Eddington versus Fitz Morris, L.J. Bowen observed in relation to a case of this nature that in order to sustain his action, he must first prove that there was a statement as to facts which was false, and secondly, that it was false to the knowledge of the defendants, or that they made it not caring whether it was true or false. And lastly, when you have proved that the statement was false, you must further show that the plaintiff had acted upon it and had sustained damage by so doing. You must also show that the statement was either the sole cause of the plaintiff's act or materially contributed to his so acting. The question then is what representation was made by the accused person with the knowledge that it was false, and did the complainant act upon that information to his disadvantage. In regard to the registration of the title, the evidence on record is that the transfer was effected at the lands office when the accused presented a transfer that was purportedly signed by David Silverstein and George Oraro, the administrators of the estate of Livia Trench, together with other completion documents. PW2, who is in charge of conveyancing at the firm of Oraro and Company Advocates, stated in her testimony that the transfer document was not prepared in their office, and that George Oraro, one of the signatories, denied signing the transfer document. The import of their evidence was that the transfer document that was presented by the accused person was forged, and therefore it was a false document. It was therefore incumbent upon the investigating officer to avail credible evidence to prove that the transfer document was forged. Unfortunately, the investigating officer failed to take that approach, and they did not call document examiners to forensically audit the transfer document. PW7, who is a land registrar from the Ministry of Lands, acknowledged in her testimony that she was the one who signed the transfer document, and that to do so, she relied on a transfer document executed by George Oraro and Dr. David Silverstein to Anthony Kimaru. She also relied on other supporting documents that were presented. The evidence on record was that the supporting documents were presented by the firm of Oraro and Company Advocates, by their conveyancing clerk, Susan Mudhoni, PW5. She stated on cross-examination that there was no caveat in place before the transfer or barring the transfer. Transfer documents appeared genuine, and so was the consent to transfer. The witness also stated that no one complained at the lands office of the transfer until the DCI wrote a letter asking for documents used to effect the transfer. In her testimony, PW5 stated that she received the mother title, which was crucial for the transfer, from their office, and left it with the registry attendant at the Ministry of Lands by the name James Muzoka. They said James Muzoka did not record a statement to explain what transpired at the lands office, and if he did, he was not called as a witness before this court. The registrar, who also recorded the entries of the supporting documents, was also not called as a witness, as indicated by PW7, that she was not the one who recorded the entries, but only signed the transfer. From the evidence in this case, as seen above, the accused had already paid the full purchase price for the said parcel of land, and several prosecution witnesses, including the administrators of the estate, confirmed that the accused had an interest as purchaser of the land, and what was remaining was only effecting the transfer of the land to the accused. There was no evidence presented that anything stopped the transfer from being effected, not even the case in ELC court in Nanyuki, as there was no order produced before this court stopping transfer. The prosecution did not produce evidence to show how the complainants, who are indicated in count 1 as George Oraro and David Silverstone, would be disadvantaged by the registration, and yet they had confirmed that they had already received the entire purchase price in full, the full purchase price. And this perhaps explains why they never filed a complaint about the transfer of this land to the police. It is the finding of the court that the elements of the offense of obtaining registration by false pretense, as seen above, have not been proved beyond reasonable doubt. The accused is found not guilty in count 4 and is acquitted under section 215 CPC. The last count, count 5, the accused is charged with the offense of conspiracy to defraud, contrary to section 317 of the Penal Code, which provides for the offense in the following terms: that any person who conspires with another by deceit or any fraudulent means to affect the market price of anything publicly sold, or to defraud the public or any person, whether a particular person or not, or to extort any property from any person, is guilty of a misdemeanor and is liable to imprisonment for a period of 3 years. The Black's Law Dictionary 9th edition defines conspiracy as an agreement by 2 or more persons to commit an unlawful act coupled with an intent to achieve the agreement's motive. And in most states, action or conduct that furthers the agreement, a combination for an unlawful purpose. Archibald, writing on criminal proceedings, evidence, and practice, states that the offense of conspiracy to defraud or conspiracy cannot exist without the agreement, consent, or combination of 2 or more persons, so long as a design rests in intention only. It is not indictable. There must be an agreement. Proof of the existence of a conspiracy is generally a matter of inference deduced from certain criminal acts of the parties accused, done in pursuance of an apparent criminal purpose in common between them. Nyamwea J, in the case of Stephen Odiaga Kikombero and another versus Republic, emphasized that the offense of conspiracy to defraud must of necessity be committed by 2 or more persons, acting in concert to execute a common intention, which is to defraud. The question is, with whom did the accused person herein conspire to commit the offenses? The investigating officer before this did not avail or lead any evidence to show that the accused person conspired with anyone else to commit the offense. The evidence on record is that he presented documents at the lands office for registration, which the prosecution alleged was not genuine. But there was no evidence that he colluded with any other person, either to prepare the documents or to assist him at the lands office. The offense cannot therefore stand where the purportedly unlawful act was committed solely by the actions of the accused himself, and consequently the accused is found not guilty in count 5 and is acquitted under section 215 CPC. So in conclusion, the court has found that the accused is not guilty in all the 5 counts and is acquitted under section 215 CPC. So that is the judgment.